Hello. Hi. Welcome, everyone. Hopefully, everyone had a nice weekend and a nice small break for me. I missed you dearly, rest assured. It's like 4 students emailed me saying there was bad traffic today, so people will be rolling in. Lexi, welcome. Welcome, guys. Okay. So I appreciate you all had a really good class on Monday night. We can't even imagine it's been that long. And we are starting a new unit today on the First Amendment. Any questions before we get started? No? Okay. It's tragic that I have to fit the entirety of the First Amendment into 3 classes. I strongly encourage all of you to take the class on the First Amendment. I know you all ignore me because about 20 people take it every year, but I encourage you. I don't teach it. It's not even my class. But this is a very important, profound class that affects people in many ways, so you should all consider taking the First Amendment class. In the next 3 classes, I will only give you a small sketch. Oh, and by the way, I used to teach a Second Amendment, but I have to cut it for a burgerful. So let's be any doubts about I'm teaching in a biased way. I cut the Second Amendment to teach gay marriage. So no one shall ever say. Actually, it's funny. One year in a student evaluation, some student obviously wasn't paying attention, wrote, "Blackman is so biased. He didn't even cover the Second Amendment. This is Texas." He didn't get it, which was fair enough. So unfortunately, we won't have time for the Second Amendment this year because a burgerful consumed that slot, which I didn't have in years past. But we will cover today and Wednesday free speech, and then on Monday, afterwards, our final day, I will cram in freedom of religion into a very short class. Not nearly enough time. It kills me, but this is the only way we can rush it through. The other ConLaw classes don't even touch First Amendment beyond just a little bit, so you guys get more than average at South Texas. Okay. Any questions before we get started? All right, so before we get to the Bill of Rights, we must discuss what came before the Bill of Rights. And I've made this point a number of times during class, but I don't think I've ever made it so emphatically. When the Constitution was being debated in the steaming summer of 1787, one of the most contentious points was whether our Constitution needed a specific list of protections to guard certain rights. Indeed, the phrase Bill of Rights wasn't really even in dialogue yet. That term came around much later. But many, in fact, most of the states had in their constitutions not just structural protections, but protections of rights. Now, by this point in the semester, you should know the difference, right? And this will serve as a mini review. Structure protects freedoms by limiting the power of what government can do. If government can't do stuff, they can't bother you, right? And the classic example is this, right? Could Congress pass a law in 1789 censoring newspapers? Let's see. Where was I up to last week? Anybody remember? I started with arrow last time, didn't I? So I'll start the lead this time, okay? Good. So Lee, in 1789, under the original Constitution, the Bill of Rights had not been added yet. Could Congress pass a law saying that all newspapers that publish harmful information about the government are hereby censored and can't publish newspapers? Could they have passed that law in 1789?
No.
Why is your answer no?
Because there was no enumerated Bill of Rights for the people yet. That was because the creator of the Constitution didn't want to.
Well, that's true. That's true. I'm looking. There's no First Amendment, right? Could Congress have enacted that law, Angela?
Absolutely. Nothing to prevent them from doing so.
You're wrong.
Tell me what.
You tell me why. I'm asking you. Where would Congress derive the power to pass a law censoring newspapers? Oh, you see where I'm going now, right? So, Angela, generally speaking, where in the Constitution does Congress's powers are listed? What part of the Constitution are we talking about? Good review.
So the powers, all legislative powers herein granted shall be vested in Congress, which shall consist of a Senate and
Yes, sir.
House. Article 1, right?
Okay, so where in Article 1 are those powers enumerated?
Section.
Something like that.
8, is it?
That's it.
Okay.
And this is what we spent, roughly a quarter of the semester on, right? The power to regulate commerce, the power to tax, the power to everyone's favorite, create postal roads, right? Everyone's favorite, right? Onslow, is there anything in Article 1, Section 8, anything at all, that in any way implicates the power of Congress to censor a newspaper?
Nothing that says they can. Nothing that says they can.
No. If Congress lacks the power to censor a newspaper, Onslow, can they do it?
Not if it's not if they cannot. According to this, no. They
Exactly. Because we have a system of enumerated powers, because Congress can only do that which is enumerated, right? If they lack the power to censor a newspaper, they can't do it. It is in this sense that the structural protections of our Constitution protect liberty. You don't need a First Amendment guaranteeing freedom of the press because Congress lacks the power to censor the press in the first place. Everyone got that important point. It's a very helpful thought experiment to think of the time between 1789, when the Constitution was ratified, and 1791, when the Bill of Rights was ratified. In that 2-year period, could Congress pass a law to censor newspapers? And the answer is no, they lack the authority to do so.
Could they not use a necessary?
Oh, you're fine. Necessary and proper clause. Does that clause stand by itself, Nuri, as a font of power?
But Congress can use it to make certain laws.
Good review. How does necessary and proper work? Does it stand by itself?
No.
Take a McCullough.
I thought it was part of the enumerated powers that whatever, however they could incorporate it.
Exactly right. So think of Macaulay, Maryland, right? Back to the beginning of the semester. Could Congress charter a national bank by itself? No. But it is necessary and proper aid to regulating commerce, coining money, right? They could then use the sweeping power to then build a bank. But you still need the enumerated power to latch onto. And there's no enumerated power, at least in 1789, that would let them latch onto it, right? But Nuri's point is exactly right. What about necessary and proper? Won't this give Congress the power to go beyond enumerated powers, right? This was the debate. So on the one hand, you had the Federalists. And the Federalists said, listen, we don't need a Bill of Rights. The structural protections of our Constitution are enough, right? There's no power to censor a newspaper. But the anti-Federalists, people like George Mason, the namesake of my alma mater, were like, Nuri. Nuri said, wait a minute. Necessary and proper. I think this may be interpreted broadly. So even if there's no direct power of Congress to censor newspapers, maybe it'll be necessary and proper to some other power they do have. This was the exact debate that was had by the framers of our Constitution. So what happened was like this. When the Constitution was first ratified, there wasn't a Bill of Rights, but there was a promise that we'll get to this right away. In fact, many of the states that voted, the people of the states, the conventions that ratified the Constitution, did so with a promise saying, we want a Bill of Rights. We don't trust this necessary and proper language, right? Maybe they'll read it broadly and give Congress additional powers. So while the structural protections of our Constitution were designed to protect our freedoms first, the Bill of Rights was added subsequent to that as a means of solidifying those protections. Everyone get that point, right? So the mere fact that we didn't have Bill of Rights in 1789, we may have never had a First Amendment. We may have never had a freedom of speech. But the idea was we don't need those. But the foresight of the Anti-Federalists proved true. John Marshall, Macaulay, Maryland, not even a few years after the ratification of the Constitution, Nuri's nodding his head, started reading necessary and proper awfully broad. Remember there was a debate between Hamilton and Jefferson. Remember this? The Jefferson said we need to read it absolutely necessary, strictly necessary. And you had the Hamilton vision saying, yeah, whatever's convenient. Well, the Hamiltonians won. And you do have this broad federal power. So in these cases, you needed to have specific provisions in the Bill of Rights. So the foresight to include these at the time didn't seem like that big of a deal. But in hindsight, it worked out fairly well. Now, the other risk of a Bill of Rights, and this was actually the concern of the Federalists, was expressio unius. Right? If we list certain liberties we have, that means those are all the freedoms we have. We have none other. Is it conceivable, people like James Madison would say, to enumerate all of our freedoms in a single list? Of course not. There was this great exchange in the Constitutional Convention of 1787 where one guy got up there from Massachusetts and drawing a blank in his name. And he said, do we have a right to wear a hat? What? He said, do I have a right to wear a hat? Of course you can wear a hat, right? Everyone wore a hat back then. Is it listed anymore? Did anyone write down that I can wear a hat? No, it was never written. This was meant to illustrate that we have rights that can't possibly be limited. And if you have this Bill of Rights, there's nothing about a hat, boom, that means the government can take away your hat away. So to solve this problem in large measure, the 9th Amendment was added. If you turn to your constitutions, it's in there. It's on page 24. And the 9th Amendment says very, very succinctly, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. At the most basic level, merely because you list these other 8 amendments, that doesn't mean those are the full extent of the people's liberties. You saw, in cases like Griswold v. Connecticut, where the justices tried to recognize all these unenumerated rights, like abortion or birth control, as a consequence of the 9th Amendment. We don't need to go too far into that, but you have to think about what it means to have rights retained by the people. What are these rights, and who gets to decide what they are? Are they rights at common law? Are they rights emanating from penumbras that the Warren Court, captures? Is this a right to dignity in a burgerful? Who the heck knows, right? But that is where the 9th Amendment came from, as a way to rebut the presumption that rights that are not enumerated are not protected. All right, any questions on this? Okay, everyone get that frame. So the actual amendment process, which I'll discuss somewhat briefly, is how amendments are added to the Constitution. And I actually had a really cool experience recently. So I was recently doing some interview with a guy, right? And, he was in my office, and I was giving a Constitution. He's like, here, let me give you a Constitution. He's like, oh, no, I don't need that. I'm like, oh, come on, take a Constitution. Like, I read it when I was in school. I'm like, okay. I was like, what grade you were? He's like, I was in high school. I was like, when did you graduate high school? 1989. I'm like, aha! You did not read the entire thing because the 27th Amendment was ratified in 1992. Take a damn Constitution. I was so proud of myself, right? This guy was trying to be a smart ass, but he had no idea, right? You read it in 1989. Good for you. Take a Constitution. You haven't read the entire thing. Anyway, so the 27th Amendment is a curiosity of American history. The perversity is that originally, we think of the first 10 amendments of the Constitution. There originally were 12 proposed amendments. 12 proposed amendments, right? The First Amendment, people say, oh, freedom of speech is first because it's so important. It was actually the third proposed amendment, but the first 2 were never ratified because they weren't that important, I guess. So the first proposed amendment had to do with how members of Congress were appropriated. Nothing too sexy, right? Not freedom of speech, for religion, how members of Congress are set up. The second proposed amendment that came out of the Senate had to do with the compensation for members of Congress. And simply put, this means that members of Congress can't raise their own pay. Any salary increase from members of Congress, oh, here, I have it. I think I have it here. Any salary increase by members of Congress take effect at the next election. This is why members can't raise their own pay. If for whatever reason, imagine every member of Congress votes to raise their pay, people get angry, they can throw the bums out of office. So increases in salary take effect the next election cycle. So the funny part is this amendment, again, was proposed in 1789. It only got 6 states to ratify, not enough. But over the next 200 years, one by one, states start to ratify this amendment. Even states that weren't in the Union in 1789. Until finally, I think it was Michigan in May of 1992, after my friend graduated from high school, apparently. It's like, all the, Lexi, does your science book have Pluto as a planet? Do you know? Okay. Well, apparently Pluto's not a planet anymore. When I went to school, Pluto's a planet. Is it gone?
Brought it back in.
They brought it back in. Excellent. So right. So
An asterisk.
with an asterisk, right? It's like a Barry Bonds planet, right? So, I would know this, right? Barry Bonds' famous home run ball, Mark Echo, the fashion designer, bought one, and he brandished an asterisk into it. And then he tried giving it to the Hall of Fame. They didn't want it. Go figure. So it was finally ratified in 1992. So is there a time limit for amending constitutional amendments? Apparently not. So let's walk through the process by which amendments can be made to the Constitution. So there are two paths by which amendments can be added to the Constitution. Oh, by the way, before I get too far into this, one of the common themes we've had in this class is the argument, is the Constitution living? Should we follow the original meaning? We've had this debate over and over again. And throughout all these debates, I don't think anyone's ever once raised their hand and say, why don't we amend the Constitution, right? Why don't we amend the Constitution? And I think there are two possible responses. So first of all, amending the Constitution is awfully hard. By design, it was not meant to be changed on the simplicity of legislation. But the second answer is it's a lot easier to appoint 5 Supreme Court justices than to amend the Constitution. And to use a contemporary example, I'll use the Citizens United case, which was decided a number of years ago. It's proved to be very unpopular in many quarters. And 2 presidential candidates this year said, I will create a litmus test to only appoint a justice who will vote to overturn Citizens United. Okay? A year ago, there was actually a proposed amendment that would have done a lot more, but at a minimum, reversed Citizens United. Didn't even get out of the Senate, did not get enough votes in the Senate. So what's easier? Appointing 1 justice to change the vote of the court, or actually go through the amendment process? And this in no small measure is why we have only had 27 amendments. The Supreme Court has taken it unto itself to effectively amend the Constitution in many respects so that there hasn't been a need for it. Indeed, we did cases involving gender discrimination. Craig v. Barron, remember the beer case, right? Around the same time, there's something called the Equal Rights Amendment. Remember this? We've actually written into the Constitution, I guess, then the 27th Amendment, that gender discrimination is unconstitutional. Rather than having trying to squeeze it into the 14th Amendment, there would have been a dedicated amendment for gender. But once the Supreme Court went ahead and said, they get intermediate scrutiny for gender, well, we don't really need that anymore. Don't really get pushing for it. We can kind of petter it out. So the Supreme Court, in many respects, has chilled the need for the constitutional amendment process because all you have to do is appoint a new justice. And then the 5-4 goes the other way, and you don't need Article 5 anymore. But it's important to remember that had the Supreme Court not acted the way it did, we very well may have had other amendments. Indeed, President Roosevelt, when he was considering his court packing plan, considered amending the Constitution. He considered let's having constitutional amendments to give the Congress the power to regulate all sorts of commercial activity, even intrastate activity. And he and his advisor said, you know what, that's too much work. Let's just threaten the Supreme Court. It'll be easier. I'm only slightly exaggerating. That was basically the discussion. Let's just try and get Supreme Court to change this. Let's not bother with amendments. Too much work. Okay. So 2 possible routes for amendment process. The first originates in the Congress. The second originates in the states. So the first route is if 2/3 of both houses of Congress. That means 2/3 of the House and 2/3 of the Senate. There's an alternate route which hasn't really been done before. That hasn't happened. If 2/3 of the states call on Congress to amend the Constitution, if 2/3 of the states, there are actually groups, I think it's called the Article 5 Project or something like that, where they're actually trying to get enough states to call constitutional amendments, maybe the Balanced Budget Amendment, that's a usual favorite, or various others. This is actually an interesting part, and this is not to get political, but the number of states that are actually controlled by Republicans is getting close to the 2/3 mark, right? They're not 2/3 of the population. The 2/3 of the states, so like Wyoming and California, are treated the same way. No disrespect to Wyoming. So I've actually run the numbers on this, and if governorships continue tilting, we could actually have 2/3 states controlled by Republicans. That doesn't mean anything, right? But this could happen in our lifetimes. I don't think you'll get to the next step, which is 3/4 of the states have to ratify. So even if you have 2/3 of the states call for a convention, then you need 3/4. I think it's actually conceivable to get to 2/3. I actually think it's possible. I don't think you get to 3/4. I think that's impossible. I made this prediction last year. Maybe I'll be wrong. I don't think in our lifetimes we'll see another amendment to the Constitution. I really don't. Trying to get 3/4 of Americans to agree on anything, that's hard. Marcos, you hand up?
When it says 2/3 of the states, is it comment on the executive branch of the state or the legislative?
So it's actually state constitutional amendments, state constitutional conventions. So states could actually, the state legislature could actually have a convention of the people to vote on this, right? Again, it's somewhat unclear exactly how this happens. So all it says is 2/3 of the several states shall call a convention. It's not exactly clear how that happens. It's probably a convention of the states. The 3/4 part, though, Congress gets to choose. So Congress could say 3/4 of legislature or 3/4 in convention. So if Congress says 3/4 of the state legislature, that means both houses of each a state. And Nebraska is actually unicameral, so they can only get one bite at the apple. So the process is very cumbersome and very tedious. And this is largely by design. A constitutional amendment was designed to be hard to enact. Now, while we're on Article 5, I want to draw your attention to two provisions. It says here, no amendments for 1808. Okay? The first and fourth clause and ninth section of the first article. You remember what that is?
Isn't that about slavery?
Slave trade. So the Constitution specifically says before 1808 you can't get rid of the slave trade. Can you have an amendment to the Constitution that can't be amended? Whoa. If the Constitution says you can't pass an amendment getting rid of the slave trade, and a subsequent amendment gets rid of the slave trade, is that unconstitutional? Whoa, right? This is the deep question that keep law professors up at night. I don't have an answer. Okay? Also, the other one, we all know in the Senate there's only 2 senators per state. You cannot pass an amendment that would deprive a state of its equal suffrage. So you couldn't pass a law saying, you couldn't have an amendment saying, okay, you know what? States now have senators based on the proportion of the people, not fixed rate. That you can't do either. All right, so any questions on that? There have been many proposed amendments that have failed. One of the most notorious is called the Corwin Amendment, C-O-R-W-I-N. It was actually proposed during 1860. And the Corwin Amendment would have basically written slavery into the Constitution. While the original Constitution was silent on the word slave, the Corwin Amendment would have said unequivocally that the right to slavery shall be protected. Rather than reversing Dred Scott, it would have written Dred Scott right into the Constitution. Ironically, that would have been the 13th Amendment, although we know now our 13th Amendment went the other direction to eradicate slavery. There was also an amendment in the 1920s involving child labor. You'll recall the Supreme Court in the child labor case said that Congress could not regulate child labor. So there was actually many states had ratified an amendment to try to prohibit child labor, although that amendment petered out. The other one of note is the Equal Rights Amendment. I mentioned that a moment ago, where I can't remember the number, but quite a number of states actually ratified an amendment that prohibited gender discrimination, but it didn't quite make it above the 3/4 threshold. Also, we have 50 states now. We don't have 13. Getting 3/4 of 13 is a lot easier than 3/4 of 50. So I don't think we'll hit the 3/4 mark my lifetime. If we do, you can come back and say you have no idea what you're talking about, Josh, but I'm pretty confident in that fact. Boy, that clock is broken. So it's driving me crazy. I keep thinking it's 40, and like we have to go soon. It's driving me nuts. Okay. Any questions on the amendment process itself? Okay, very good. So we start our cases today in what is actually the first case in the book. I don't know why they put it first, but whatever, it's there first. Barron v. City of Baltimore. All right. This is probably one of the most significant constitutional cases in the early years of our republic. So we look at the First Amendment. I know this is a Fifth Amendment case. Let's start with the First Amendment, right? Tim, what's the first word in the First Amendment? The first Congress. Congress shall make no law. We often joke they should have stopped right there. There it is. Congress. There it is. There it is. I love the delayed reaction. Congress shall make no law, right? So, Tim, based on that amendment, who does the First Amendment control?
It's at the federal level, or I mean at the
I'm looking at the text. What's it say?
Congress.
So who does it control? Just the
Congress.
text. Does it control the president?
No.
Does it control the federal courts?
No.
Who does it control?
It's Congress.
What about the states?
States wouldn't be under that control either.
Okay. So everyone, go to the Fifth Amendment in your Constitution. I didn't put them all up there, forgot. The Fifth Amendment. This is where the takings clause is from, and I'm sure you said this in property. I was teaching it not even 2 hours ago, so it's a fitting continuation. I forgot what class I was in before. I thought it was ConLaw, I was teaching about takings clause. So now, Michael, is there anything in the Fifth Amendment about Congress? Does it say who it applies to anywhere in the Fifth Amendment? No, but let me make this point very clear. Michael, does the Bill of Rights give any rights to people?
It preserves, well, it limits the power that government can.
Very important point. I can't make this one clearly enough. The Bill of Rights does not confer any rights on people. It's the misnomer of the millennia, okay? The purpose of the Bill of Rights is to constrain government, not to grant rights. Let's just go right down the list, my friends. Congress shall make no law respecting the establishment of religion. Congress shall make no law abridging the freedom of speech. Does the Constitution say you have the right to free speech? No. It says Congress cannot infringe it. This presupposes that a right to free speech existed before the Constitution was ratified. Imagine that. The freedom of speech, whatever that is, that antedated, that preceded the Constitution. The right to keep and bear arms shall not be infringed. Does this mean they give you a right to bear arms by the Constitution? No, these are pre-existing rights. The right of the people to be secure in their homes in the Fourth Amendment, right? Does that mean you have the right to be secure? No, that precedes the Constitution. Private property can't be taken for public use. What's private property? That comes before government. And this is a point which, unfortunately, schools don't teach at all, and most law schools don't teach it either. Our Constitution doesn't even pretend to grant rights. That's why we have an opinion like a burgerful. It's so hard to swallow, because it says now you have a right to get marriage from the government. That is wildly inconsistent with our notion of liberty. It's antithetical even. This is why Justice Thomas's dissent on positive versus negative rights is sound in terms of history. Now, if you want to make stuff up, fine. But we do not have a Constitution that gives us positive rights to stuff. Not a right to a marriage license, a right to free speech. Our rights come before. Now, where do they come from? Are they natural rights? Are they rights from the common law? Are they rights from the Creator that we're endowed with? I'll leave that for the philosophers, right? But the minimum, our Constitution recognizes rights that come before government. Rights do not come from government. I can't stress that point enough. Okay, any questions on that? All right, so let's go back here. The whole point was making. Yes. So let's see, Pam. Is there anything in the Fifth Amendment that says which government is controlled by it, where it says, nor shall private property be taken for public use without just compensation? Who cannot take property, Pam, without giving compensation? Does it say in the Fifth Amendment? Which government? How do you know that? Okay. So the Constitution is framed in the passive voice. We're not doing a passive voice. There's no actor. There's no verb. The First Amendment is actually the outlier because it says Congress shall make no law. But the other amendments in the first 8 are framed passively. We don't know which government. Is it the state government or the federal, or what's often called the general government. Yes, when John Marshall writes the general government, he's talking about the federal government. He didn't explain that, but I'm telling you that's what he means by that. Okay. So we have a case, Barron v. Baltimore. Okay. So Joseph, tell me, what were the facts here in Barron?
What I understood, the plaintiff was complaining that Baltimore Harbor.
A little bit louder?
The Baltimore Harbor, I'm not sure what exactly he did, but they made the water too shallow.
Okay.
He brought up the claim that they took his property.
Okay, now did you do takings and property?
Sorry?
Did you do takings and property?
We're taking a look now.
Oh, I always forget. You didn't get the takings yet?
On property one.
Oh, you're on property one. Ah, okay, good. I can teach another class. I never keep track of one of the people's classes. Sorry. So, fair enough, Justin. Sorry. So, the Fifth Amendment says that private property, I'm sorry, I'll read it to you just to get it the first time correctly. Okay? Nor shall private property be taken for public use without just compensation. Okay? So, broadly speaking, and in the modern era, when the government wants to take your property, they have to pay you for it. So, the government wants to knock over your house to build a road. They have to pay you just compensation for the diminution in value of your property. But what if they're not actually taking it physically, but they're diminishing the value? In this case, they remove the water from the wharf, which is like a harbor in Baltimore, so that his business became worthless. They diminished the value of his property. Under modern day takings law, that probably also would not be a taking. Maybe, maybe not. But he claimed that they basically diminished the value of his property. He was relying not on the state constitution, not on the Maryland Constitution, but on the federal Constitution. Why wasn't he relying on the Maryland Constitution? Because they didn't really have a provision that helps him out. Had there been a provision in the Maryland Constitution to help him, he would have relied on it. There wasn't, so he turned to the federal Constitution. And he asserted that the federal Constitution, the Bill of Rights, puts a limitation not only on Congress, but also on the powers of the state. That the state's police power was cabined by the Bill of Rights. Now again, we are before the 14th Amendment. Later on, we discuss the Incorporation doctrine. The Bill of Rights was extended to the states. But in 1830, whatever year this case was, 1833, we don't have a 14th Amendment. Okay? So Michelle, how does Marshall analyze whether the provisions of the Bill of Rights apply to Congress or to the states or both? What's Marshall's mode of analysis?
If I'm correct, he went straight to the Constitution, focusing on Article 1, Section 10, limits the states based on what Congress can do and what states cannot do.
Mm-hmm.
So he says there are some things that can be done concurrently,
Uh-huh.
like taxing, but just not the same thing. They can tax on the same thing. So that being said, just sort of so the Constitution was created to limit the federal government. So in that thinking, that I said that leads me to say that the Fifth Amendment applies to what Congress cannot do.
Okay, good. So Marshall's opinion here is very neat. It's very precise. And he looks to the text of the Constitution. And in particular, he compares Article 1, Section 9 and Article 1, Section 10. It's in your Constitution on pages 9 to 10. Oh, well, perfect. Section 9 is on page 9, and Section 10 is on page 10. Right? That was totally unintentional. So what Section 9 does is it puts limits on the powers of Congress. Okay. Section 10 puts limits on the powers of the states. So Marshall reads these two sections in a very deliberate fashion. If Congress had meant the same sort of limitations to apply to both the state and the federal government, why would they have separated them into sections 9 and 10? respectively. And specifically focused a lot on this provision about bills of attainder. You'll recall a bill of attainder is a law passed by the legislature that specifically punishes one person. It's like passing a law saying, Congress votes to remove Mr. Chadha from the United States, right? INS v. Chadha. Okay? Those are unlawful. So we have here Article 1, Section 9. And it says, no bill of attainder or ex post facto law shall be passed. Right? Now, Andrea, is there anything in Section 9 suggesting that's limited to Congress? Just reading Section 9 by itself. Is there anything in that sentence up here suggesting that limits to Congress? No. Okay. But then we go to the next part, Article 1, Section 10. And it says, no state shall pass any bill of attainder. So, Andrea, is that section limited to either states or federal government? Speak.
Now it's limited to the state.
Okay, so now here, Andrew, here's a hard question, right? You got an easy 2 ones, right? If this one is limited to the states, how should we understand this one? If this one specifically says no state, how should we understand that one? Congress, yes. Why? Why should we understand this one to be applying to Congress? Right. So think about it like this, right? This one clearly says states can't pass both bills of attainder. If this also was states can't pass bills of attainder, it'd be surplusage. It'd be the same thing twice. And we start from the presumption that the Constitution does not waste words, right? You don't have the same provision twice. So the only way to read these two things in harmony is Section 10 goes to the states, and Section 10 applies to Congress. Everyone with me so far, right? But Tam, this is passive voice. It just says no bills of attainder shall be passed. Does it matter that that's passive voice, that the word Congress isn't there? Should it matter? Why not?
Because, in Section 10, it's already says state.
Yeah.
It's already mentioned state. So Section 9, Congress.
Good. And the focus here is it's on the passive voice. So Marshall says the mere fact that it says no bill of attainder shall be passed, passive voice, that's the same phrasing in the Fifth Amendment, right? The Fifth Amendment says, nor shall private property be taken for public use without just compensation. The same phrasing where Congress is not mentioned. But because we know that this sort of phrasing is used for federal power in Article 1, Section 9, the same rule of construction applies to the Fifth Amendment. Everyone get that? It's actually Marshall does a lot of weird BS-y things in other parts of the cases, but this was actually a very elegant textual move, the way he does this. It's actually one of my favorite opinions of his. He's actually convinced me this is right, which usually he fails to do. Marbury was wrong, McCulloch was wrong, Gibbons was wrong. This one I think is right. This is why people worship John Marshall. I'm like, hold on. Read him. Okay? But then Marshall makes another point I think is also very good, right? Terry, why would this people ratifying the Constitution have wanted to make the Bills of Rights apply to states? What would the reasons have been? Why would they do that?
Or they want them to?
Yeah, why would they want to do that?
Well, people want it because they may have more protections under that. than other states.
Oh, but that's wrong. Why is that wrong? Which can provide more protection for the people, the federal constitution or the state constitutions?
The state should. They're closer to the people, and people elect those indirectly.
Okay, I'm going to get to what you were getting at in a second, because the real answer is slavery. But to start, right, the theory is, what's easier to amend, one state constitution or 3/4 of all the states? A state constitution is easier to amend. So if anything, those who framed our federal constitution would say, you know what, the liberties should provide in our local, we can amend our constitution easily. We can provide more protections than the U.S. Constitution, right? The idea was we can provide even additional liberties with a much less cumbersome process. But this was a thinking, at least, right? That the states will be the guardians of their own states' liberties, right? But Nina, where did that one fall flat? Where did that aspiration die? So the premise was that the states and their state constitutions would be able to guard the liberties of their people, right? Historically, where did that aspiration fall? Why didn't that work out in practice, letting the states take care of the liberties of their people? What states in particular? Who was excluded from state constitutional rights? Slaves, yes. So the experiment didn't quite pan out, right? The experiment of the Bill of Rights was, let the states have their own freedoms, let the states have their own police power, and the states will protect the liberties of their citizens. But as history played out, that didn't work, because the southern states specifically went about depriving their slaves of these rights. And we think about the manner in which slavery worked. They violated every conceivable right you can imagine. They denied freedom of the press so that they couldn't publish abolitionist newspapers. They deprived freedom of religion. Abolitionist pastors were actually jailed rather than giving, sermons on abolition, right? They were denied the right to peaceably assemble. If too many slaves were in one place, they basically killed them. They were denied the right to bear arms. And this is why I'm going to go on briefly. The first gun control laws in the country were passed in Georgia, of all places, as a means to disarm blacks, right? Slave masters said, you know what? We don't want our slaves being armed. So some of the first gun control laws were actually aimed at depriving blacks the right to defend themselves against the Klan and other such groups. Okay? Jury trial, forget it. You didn't get a right to a jury. If you were a slave accused of a crime, you'd be lynched. Due process of law, forget about it. You weren't given anything. Right to a trial, a jury trial for civil actions, forget it. Cruel and unusual punishment, not even close. So the southern states systematically violated virtually every provision of the Bill of Rights as a means of upholding slavery as an institution. So this idea that the states would promote and protect the liberties of the people, frankly, proved to be short-lived. And indeed, when we speak about the framers of the Constitution, I made this point before, we don't stop in 1787. We don't stop in 1789. We don't stop in 1791. We have to keep going at a minimum to 1868 and then a little bit afterwards, right? With the ratification of the 14th Amendment. Because it's the ratification of the 14th Amendment that altered and radically changed the structure of government in our country, where it was no longer the province of the states to guard the liberties of their citizens. That experiment proved not to work out so well. Where now the federal government now had a distinct role in protecting the freedoms of their citizens. And this was with the ratification of the 13th, 14th, and 15th Amendment. We've done this already, folks, right? We discussed the 13th Amendment, eradicating slavery. The 14th Amendment, providing the privileges or immunities and due process of law and protection, and giving Congress the power to enforce those rights. And the 15th Amendment, allowing the right to vote, regardless of your race. We later have a suffrage for women, so women can vote. Process keeps going. And then finally, in 1992, we have Congressional Pay Amendment, kind of an anticlimactic crescendo of the amendment process, as it were. So we've discussed before the powers of Congress to enforce the 14th Amendment in cases like the civil rights cases and others. But I want to focus now on a doctrine that I've alluded to before but haven't really discussed clearly, which is called incorporation. Incorporation. So it was absolutely true when John Marshall wrote Barron v. Baltimore that the Bill of Rights, the first 8 amendments, did not apply to the states. I think he was right. I think this is actually one of the few opinions he was correct. But the 14th Amendment changed that. How it changed it, this is actually subject to a lot of debate. And this is a case where the Supreme Court almost certainly got it wrong. And again, there's debate on this. So we discussed this before. The 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. What are these privileges or immunities? There's a debate on this, but a lot of people, myself one of them, think that these privileges or immunities included the first 8 amendments to the Constitution. I'm sorry, the first 8 amendments to the Bill of Rights. Now, if you look at the speeches that were read in Congress when this amendment was being debated, it specifically rattled off the first 8 amendments to the Constitution. This would seem to me a good fit. States can abridge the first 8 amendments to the Constitution. Just next to privilege and immunity, that said the Bill of Rights, right? States can abridge the Bill of Rights. Wouldn't that be a very elegant way of reversing Barron v. Baltimore? Wouldn't that be a neat way of saying, you know what, Barron, not anymore. States can no longer violate the first 8 amendments. Okay. Again, this part's a little bit more controversial. I think the PRI clause extends beyond the Bill of Rights to various other unenumerated rights, but I'll leave that one aside for now. So at a minimum, it includes the Bill of Rights, the first 8 amendments. Now, you guys read slaughterhouse cases. And the slaughterhouse cases, the court said, no. This does not include any unenumerated rights. It doesn't even include the Bill of Rights. It includes a list of stupid federal rights, like the right to access the Treasury and protection of the high seas. Slaughterhouse was wrong. It got, virtually everyone agrees slaughterhouse was wrong. Some don't, but virtually everyone agrees slaughterhouse was wrong. They got it wrong. But as a result, they basically crossed out the first part of the 14th Amendment. They just put it in red, they crossed it out. So then how are we in a place today where the freedom of speech applies to the states if they kill privileges and immunities? So a funny thing happened on the way to constitutional law. The court shifted one sentence down. So instead of using the most natural fit, that the states can't abridge the substantive rights, they turn to the due process clause. And we've discussed this before with Lochner, but perhaps due process should be read as a procedural right, the right of process, that you can't be denied something unless you're giving a hearing or a trial. That isn't quite right. There are probably certain substantive components of liberty, for example, the trial where everyone starts stoning these women. Is that fair? But the court seized on this word liberty. The court seized on this word liberty. And they said, you know what? Certain liberty interests are so important that you can't take them away no matter how much process you're given. No matter how much process you're given, you still can't take that liberty interest away, right? No matter how much process you're given, you can't censor a newspaper. No matter how much process you're given, you can't, make someone convert to a different religion, right? This word liberty was then seen to embrace substantively, can't even say it, right? To embrace substantively the liberty interest in the first 8 amendments, right? It's as if they were incorporated or extended through the liberty provision of the 14th Amendment. So when the Constitution says you cannot be deprived of liberty without due process of law, pretend that means you cannot be deprived of the right of free speech, right? You cannot be deprived of the right of freedom of religion, free exercise. Your right to a jury trial, your right to a criminal jury cannot be excluded, right? These are all the sorts of liberty interests that have been extended to the states. Now, did this happen all at once? No. Justice Black famously argued in favor of total incorporation. The idea that with the ratification of the 14th Amendment, the entirety of the Bill of Rights, all of it, was immediately incorporated or extended to the states. Justice Black's theory never quite caught on. The theory that won the day was called selective incorporation. Selective incorporation, or what's called jot for jot. What does that mean? One right at a time. In other words, over the course of 70 years, each specific provision of the Bill of Rights was coming up and saying, you know what? That one's incorporated. That one's not. This was incorporated. That one isn't. So rather than bringing them all in at once, the court did this silly thing where every time a right came up, it was incorporated. Okay? Now, when I was in law school, it was a big deal of saying, is a right incorporated or not? Now it doesn't really matter anymore because it doesn't really mean anything, right? With the exception of 3 small provisions. The Third Amendment, the right to a grand jury indictment, actually 4. The right to a civil jury trial, and the right to a unanimous jury verdict in criminal cases. Those are the only 4 provisions of the Bill of Rights that have not been incorporated. I'll say them again. The Third Amendment, the right to a grand jury indictment, the 7th Amendment right to a civil jury trial, and also the right to have a unanimous criminal jury against you. So in many states, if you're charged with a crime, you don't get a grand jury to indict you. Instead, the prosecutor files something called an information. Anyone ever hear about those? Not familiar? In some states, like California, for example, you can be charged with a crime merely because the prosecutor files a document against you. You don't need a grand jury to convict you, or to indict you. The lonely Third Amendment, protecting quartering of troops, has not been incorporated. This actually came up fairly recently. What was the case? I think it was in Nevada. And these cops wanted to conduct a sting operation in this guy's apartment. And they basically wanted to put themselves into an apartment to watch some drug dealer going across the street. And the guy was like, I'm not letting you in. And the cops came in anyway to monitor the situation. He sued them under the Third Amendment. So the main question is whether police are actually part of the military. And the court said they weren't. But in any event, the Third Amendment was not incorporated. So you can't get that in there. The other weird one is the right to trial by jury. The 7th Amendment guarantees a federal right to trial by jury. States do not have to give it to you. The final one is weird. In Oregon, and I think Louisiana is the only other state, you can be convicted for a crime with a non-unanimous jury. So in virtually, I think in 48 states to be convicted, you need the jury to be unanimous. In Oregon and Louisiana, you can have like a majority, I think it's like 8-2 or like 10-2 or some ratio. You can have a non-unanimous jury. Weird. Why is that right not incorporated? A very weird case that doesn't make any sense called Apodaca v. Oregon. Don't worry about that one. All right. But for the most part, all rights apply equally to the Constitution, the federal government, and the state government. Okay. So usually if I say, Texas passes a law banning flag burning, it's not really a First Amendment case. It's a 14th Amendment case, because actually we're questioning whether the law banning flag burning by Texas violates the 14th Amendment liberty clause. It's not actually a First Amendment case. All right. Any questions on that? Yes, sir.
Well, I guess going back to the Third Amendment, so if there was some type of national emergency, and I was just wondering, I guess if the state formed a militia or some kind of...
No, I got a better one.
Okay.
So this actually happened a number of years ago. So it was during a natural disaster in a federal park. Some federal park ranger, basically said to some guy, I need to stay in your house because it's an emergency. The guy's like, screw this, you can't come in. And the guy came in anyway. I mean, I might be exaggerating. I think those are the facts. So you actually do have Third Amendment claims. I think that was successful too. So no. Oh, I remember. Because he was a park ranger. He was not a troop. So unless you have federal quartering of troops, I think the Third Amendment is not good. There was an article in the Onion maybe about 10 years ago, and the headline was like, Director of Third Amendment Society congratulating another year of not being invoked. Like he was like saying, yes, with the Third Amendment Society, we're glad another year we haven't had to, having litigation. We're very happy about this. It's there. It's there. By the way, it's only in times of peace, though. The exact phrasing. It only says, no soldier shall in time of peace be quartered without consent to the owner, nor in time of war, but in a manner prescribed by law. So in a time of war, Congress could pass a statute forcing you to put up some troops in your backyard. So anyway, there's that. I'd like to even try that in Texas. That wouldn't work too well. Yes, Debbie. Technically speaking, flag burning, if Texas passed the law forbidding flag burning, is a 14th Amendment case. Because you're questioning of whether the law violates the 14th Amendment's liberty provision. In normal conversation, of course it's a First Amendment. But if you guys will be smart, right? If it's actually a 14th Amendment case, now you know. The best way of saying it's a First and 14th Amendment case. Understood? Come on in, it's okay. All right, any other questions on incorporation? Yeah, there are all these complicated tests to decide whether a right should be incorporated, whether it's implicit in the concept of order of liberty. None of that stuff matters anymore because Justice Kennedy, it doesn't really matter anymore. So I think things which I used to probably teach, I don't teach anymore because it doesn't matter. Yeah.
The textbook says something that this is the First Amendment through the 14th Amendment. Is this what it's talking about?
Yes, exactly. So if you want to be very precise, you say it's the First Amendment as incorporated through the 14th Amendment. That'd be the precise, delicate way of saying it. All right, other questions on incorporation before we go on? Okay, so let's do let's run to the First Amendment. Really, an hour in. Hopefully, this is exactly what I want it to be. So the First Amendment is the amendment that most people think of when they think of the Constitution, and I blame public schools for this. It's the only part they actually bother teaching. They usually don't teach it correctly. So there are 6 specific provisions of the First Amendment that I want you to understand. If you want your little book, just write 1, 2, 3, just number them out. But there are 6 separate, distinct provisions in the Bill of Rights, in the First Amendment. So first, Congress shall make no law. They didn't stop there. They kept going. Congress shall make no law respecting number 1, an establishment of religion, or prohibiting 2, the free exercise thereof, or 3, abridging the freedom of speech, or 4, the press, or 5, the right to peacefully assemble, or 6, to petition the government for redress of grievances. Okay. We're going to do number 2 on Monday. We'll do free exercise on Monday. I don't have time to do number 1. I wish I could, but I want to make one thing very clear. The phrase separation of church and state does not appear in the Constitution. It does not. That phrase emerged from a letter that Thomas Jefferson wrote to the Danbury Baptists, saying that we need to erect a wall between church and state. And then Justice Hugo Black cited this, and President Kennedy said in a speech. This is a phrase nowhere in the Constitution. And indeed, establishing religion literally meant establishing a state church. It may surprise you, for the first 100 years of our country, states had official religions. Massachusetts and others had state churches. Those slowly petered out, right? It was actually Congress which could not establish a national religion for everyone. States could have them. Indeed, this part blows your mind. This is actually a federalism provision, right? This means that Congress cannot intrude on the state's power to have an official religion, right? That Congress cannot intrude if the state wants to have a church. This is why Justice Thomas writes, and it could be right or wrong, that you can't incorporate the First Amendment Establishment Clause. It's a federalism provision. It was meant to prevent Congress from intruding into the states. We don't have time for that. That's all I'm going to say. But it's a I took an entire class in law school on the free religion clauses. Yeah. Where I went to law school, a class on free speech, another class on free religion. We crammed them in here. It's not nearly enough. The final 2, peacefully assemble and right to petition the grievances or government for redress of grievances, right? These 2 clauses don't really mean much anymore. Along with the free press clause, the court has basically squeezed everything to freedom of speech. Any act that may or may not involve speech is considered speech. If you're assembling, it's speech. If you're writing a grievance, it's speech. So really, the green, abridging the freedom of speech, this is where everything boils down to. So even though there are 6 provisions there, the 2 involving religion stand by themselves, but the other ones all basically boil down to speech. Any questions on that? So we start, and the book frames this in its own little way, but I'll take off a bit. What's speech, Marcelo? Oh, Nuri left just about to call him. He's next, right? Don't I'll get to him. Marcelo, what does it mean by speech? What is speech? Okay, so I'm talking to you right now, right? Are we engaging in speech? Okay. If I were to write in the board, not that I would ever actually write, you'll never see it. If I were to write in the board, is that speech? If I use a printing press and I churn out, pamphlets, is that speech? If I sing a song, is that speech? If I paint, a mural on the wall of an apple, is that speech? If I dance, is that speech? If it's an exotic dance, don't use your imagination. Is that speech? Lord help me, right? If I design a computer game where people are ripping people's heads off and it's realistic, is that speech? If I design a computer program to create an image of an underage child who's naked, is that speech? Ooh. It's not real, it's Photoshop. Basically took an adult and made it look like a kid. That's speech. If I burn a cross on my own lawn, is that speech? Okay. If I walk up to you and I'm going to punch you in the face, and I don't actually do it, is that speech? Okay. If I go to a Muslim civic festival and I carry around a pig's head on a pike, reading for Wednesday, is that speech? Okay. If I'm not just calling you now, but you can keep saying yes, right? If I go around saying that I'm a Medal of Honor winner, I won a Medal of Valor, in the military, and look at me, I've never done that, right? That speech. If I go around and I lie and I tell people I'm a military hero, that speech. If I put in the internet files that can be used to make a 3D printed gun, is that speech? That's actually a case I'm litigating. Yeah. So the main question, the main work that's being performed by the First Amendment falls in the threshold question of, is something speech? Once the court determines that something's speech, for the most part, it can't be regulated. There are exceptions, right? There are exceptions, and we'll go through the exceptions later. But those exceptions are narrow and far and few between. So the major question involved is something speech? And Marcel, I appreciate your yes manish, right? You keep saying yes over and over again, right? But these are the sorts of questions I listed off from real cases that have been decided by the courts about what constitutes speech. And I started off with the very easy ones, like writing, reading, singing, dancing. Like dancing, even exotic dancing, right? Courts have held that nude dancing is a form of protected speech. There have actually been strip clubs, I swear, that put a performance of Shakespeare while the girls were naked as a way to get around bans, because it has artistic and literary value. Happened, right? And then we move on to other things. Lies. If I walk around saying that I'm a Medal of Valor, Medal of Honor winner, lying. Can the government punish me for my speech? If I put a cross on my private property, on my front lawn, and I light it on fire, I don't say anything, I light the cross on fire. That's speech. If I engage in if I produce some sort of pornography, Lexi, your mom said you can hear this, so it's gonna get a little rough, right? But if I produce pornography, for Wednesday, if you read the Crush Films case, the Stevens case, I wonder what a crush film is. Okay, crush film is a type of pornography, it's a fetish where women in high heels stomp on little animals, on gerbils and cats and everything else. People get off on this, right? I actually asked her in advance if I could do this. She said yes. I warned her, it's gonna get worse, right? Is that speech? If you have a video game that involves, almost realistic expressions of, people robbing and stabbing and killing others, and it looks real, that's speech. The case I mentioned, if you use Photoshop to create something that looks like an underage a girl, make it look like child pornography, but it isn't, the model is actually an adult, is that speech? And the case I mentioned, I'm actually litigating this case. Files that can be used to print a 3D gun, are those speech? I'm litigating on an appeal to the Fifth Circuit now. If you want to see the facts, that was my exam last year. It's a real case. I'm not actually a lawyer too. I do stuff on the side. So the question of whether something's speech is one that's divided the justices although they're trending in the direction towards having a broad conception of speech. Believe it or not, the Supreme Court has a movie theater in the basement, and it's not for hanging out. During the 1950s and 60s, there were a lot of cases involving pornography and obscenity. Now, people always say, oh, it's like pornography, you know it when you see it. Now, that's wrong. Obscenity, you know where you see it. Pornography is allowed, obscenity is not. What's the difference between pornography and obscenity? We don't really know. But the justices would actually sit and watch these obscenity films to determine if they cross the line. And Justice Hugo Black, if you remember I mentioned a few moments ago, he was a textualist. He was the first textualist long before Antonin Scalia. And he would say, Congress shall make no law. No means no. So Justice Black would say, you know what? I don't need to watch this stupid movie. If they're trying to censor this film, it's unconstitutional. Okay, but the justices never adopted that sort of broad framework to decide when something violates speech. So they would actually watch and think, what's the artistic and literary value? Does it contribute to any kind of society? You know, what is this speech business? So one of the first questions we have to ask ourselves, right, is what category does this speech fall into? And a lot of First Amendment is based on categories of speech. What kind of category of speech is it? And at the core, the center of free speech is speech about the political process, right? Think of the Federalist Papers. You know, these were the first pamphlets to argue in favor of the ratification of our Constitution, right? Political speech is considered the center, the most important aspect of our society. Some may say that political speech is more important than crush films. I'm sure people in this room would probably agree to that. But free speech cannot be limited to political speech for the simple reason that when the government can pick which speech it likes and which speech it doesn't like, it gives the state the power to start limiting information that is unpleasant. And this is a point which I need to raise in particular because of things going on in the world today. Lexi, pay attention to this one. So Lexi, if I can call on you, if I may. What grade are you in? Sixth grade. So you ever hear the expression hate speech? No? Good. There's no such thing. No such thing. There are hate crimes, for sure. If you engage in an act of violence with a wicked intent, a mens rea of hate, that can be used as a factor to aggravate the crime. But there's no such thing as hate speech. It doesn't exist in this country. Other countries it does. We don't have it. And all too common today in our society and college campuses even, there's a theme that speech that you find offensive or hurtful or triggering, if I may, is speech that's not worth hearing. This is fascism. It's fascism in the worst sort. To shut down ideas you disagree with is to deprive us of the basis of knowledge. And in far too many debates and far too many classrooms, ideas that people find offensive are just stricken. So a very common trait in this is something called a trigger warning, which you may have not heard of. But you actually see some college syllabuses, right? A warning next to a book saying, this may offend you. Colleges have put these, you ever read the book Tom Sawyer or Huckleberry Finn? Oh, come on, kill me, Lex. Has anyone ever read Tom Sawyer and Huckleberry Finn? Okay, we all read these in high school, right? These books depict slavery. And it's probably uncomfortable for a lot of people. Schools are now taking Tom Sawyer and Huck Finn off reading lists because it may offend students. Anyone ever read Greek mythology? Yeah. Zeus, right? He had his way with women, didn't he? He raped them. It's very unsettling to read, perhaps. Schools are now taking Greek mythology off syllabuses to read. I can go on, but I don't need to. In The Atlantic, there's a great article about a month ago by Greg Lukianoff and Hatfield about censorship on college campuses. But Lexi, one thing I want to take with you, and forget everything else to say, that's fine, but one thing to take with you is offensive speech is at the core of our First Amendment. The First Amendment exists to protect offensive speech. We don't need government to protect speech that makes everyone happy, right? Happy speech everyone loves. But defense is the speech that makes us feel uncomfortable that warrants the greatest protection of government, not the other way around. And if you see on college campuses today, you know, protests, and the protests are worthwhile and they serve valid causes. But when, you know, professors start saying we need muscle to get rid of journalists taking pictures, we are in trouble. When we have students protesting speeches and shouting down speakers, we're in trouble. Because the students in college today become the professors and judges tomorrow. We are screwed. I am a millennial by affiliation, by birth, but I fear for our generation. These are the sort of people who are coming of age in an era where offensive speech needs to be stopped, right? I actually love South Texas for a lot of reasons, but one of the reasons why is you guys don't give a damn, right? If I mean this sincerely. If I offend you, it's like, all right, whatever, you offended me, right? If I bothered him, it's like, okay, let me raise my hand and say something back to him. If I disagree, you counter speech, right? You let people speak. I know you're not going to agree with everything I say. I don't even try. I don't pretend it. I'm not going to agree with everything you say, right? But having a discourse and debate is at the central of liberal education that's existed since the time of Sophocles, right? And Aristotle, the debate and discussion. What we cannot have is a stifling of debate. We can be sensitive. We can care for others. We cannot shut down debate, especially in state-run institutions that are governed by the First Amendment. So, Lexi, I appreciate your attention. You can go back to the, you know, your homework, whatever. But keep this with you, okay? I gave a lecture to a group at Yes Prep about a month ago. It's a, you know, it's a charter school here in Texas, and I made sure I told them, like, listen, you guys, you're going to college. These are good kids. They're all going to college. Like, you're going to college next year. Make sure you stand up for free speech on campus because it's a dwindling concern. Even among professors, and it's scary stuff. Mark? Anyone have a comment? Again, I love comments. I love when you guys disagree with me because that makes you think, right? That means I know that you're thinking critically. Far too many students are only taught things they already believe, which reinforces it, which is why, again, I'm happy I'm teaching ConLaw because I'm challenging some of your priors. I'm challenging the stuff you believe, which you may not always get.
Okay. So, the dean of the school of Missouri, and I think the president, and then I think the chancellor, they've stepped down. Do they have any cause of action regarding occurred here? Because I guess they were protecting, or some were saying they were protecting the speech.
So let me give you another example. You may recall, was it University of Oklahoma last year? A bunch of frat boys were on the bus, and they started singing a ditty with the N-word in it over and over again, right? They weren't on school property. They were on a bus going to some sort of dinner or something, right? Using racial epithets, especially in a song that you know, they were just trying to be idiots. And of course, someone put it on his iPhone and recorded it, right? Is that constitutionally protected speech? Absolutely. Now, if you use that word in a threatening manner to someone as a true threat, we'll get there in a minute, that could be a cause of action. But merely using a word someone finds offensive, that's protected. Especially if it's on a video, no one was there, there was no concern for a threat at the time. The president of the university, a guy named David Barron, who was a former US senator, immediately expelled the students who led that. Absolutely unconstitutional. Absolutely unconstitutional. There's no basis for this. He claimed that they create a hostile learning environment, right? This is the safe space mentality, that if you create a space that people feel unsafe, this speech is too offensive. Poppycock, right? That's not how the First Amendment works. The First Amendment does not have safe spaces, all right? You cannot use a statute governing hostile learning environments to trump the First Amendment. I think I blogged about this at the time, but they're supposed to. But you know what? The students withdrew because they don't want to be put through this ringer. Right? They don't want to be put through this thing of having their public lives ridiculed. So they didn't sue. They could have, but they didn't. There's actually a good group, and I don't need to plug, but it's called FIRE. Was it FIRE? Freedom, Individual Rights, and Education, or something like that. And they often litigate these cases. There's actually a case recently from Brenham College where they make Libel and Listeria, apparently. Yeah. Too soon? Yeah, yeah. Oh, sorry. Thank you. Yeah, Blink, but it's in Brenham, right? Yeah, but you know what I meant, right? And there was actually a student who wanted to hand out, she was trying to hand out placards with the Second Amendment on, little note cards. And the school said, you can't hand these out. It's a state school. They said you have to go to the First Amendment zone, which is like this place all the way in the corner of campus to hand out them. There was actually a school in California, I swear, where someone on Constitution Day wanted to hand out constitutions. And the school said, you can't hand these out. You have to go to the First Amendment zone. Inmate in the asylum, yeah.
On that note, there's a couple of other situations that I've seen recently where they had to get approval through some office on the campus to use those like free speech zones.
Yeah.
How does that function?
So the short answer is government can regulate speech in a certain time, place, manner way. So they can regulate the time, place, manner you speak. But on a college campus, a sidewalk in particular, you can speak wherever you want. Right? You're not holding a parade. You're handing out pamphlets on a sidewalk. So no, that doesn't work. But yeah.
Well, the Mizzou thing was, these people are out there saying, protesting on the public, and then they didn't want it filmed because you have to respect their privacy. Which kind of threw me for
if you're in a park on a state university campus, you don't have any. You're in public.
But watching that whole video was.
Well, if you know what I'm talking about, if you just Google, if you go to the FIRE website, you can watch these videos later. Anyway, but again, I like South Texas. You guys, you're real. Like, I don't say this as like a patron thing, but you're actual people, right? You're not in this weird bubble that so many elites are in, and I like that. It's cool. Yeah.
So I think it was a case last year. I think the teacher actually ended up resigning. She's a college or a high school teacher actually. She I think resigned. Basically, same thing as the reason their kids withdrew from the university. They didn't want to go through the rigmarole and publicity of litigating the case. But she basically, I think she was reprimanded for speech that was on her personal time, but she was a teacher at a local high school.
So public employee. So if you're a public employee, whatever you want. There are exceptions to this, but if it was on a personal time, I think I read about this case.
I know at least at our school, we signed part of our contract as like an ethics clause, where it says we can't post anything that could potentially affect our students.
Yeah, I think that's unconstitutional. I actually, the Harris County Sheriff's Office had a similar policy last year. Some reporter called me about it, and it was like when Garcia was still the sheriff that like if you remember the office, you couldn't put anything in your Facebook that disparaged. Remember this? It was unconstitutional the way they framed it. It was too bad. Yeah, Lee.
Do you think of prosecutors that are using like rap videos and stuff posted online to connect gangs and murders and stuff like that?
Well, connecting is one thing. The other issue, and this is a case called Alana decided last year, is what happens if I put, okay, everyone knows what Eminem is, right? Eminem is lyrics that basically have very vocal and graphic descriptions of murder and rape. It's in his lyrics. Is he issuing this lyric against anyone in particular? No, it's general, right? Could Eminem be arrested for threats in his lyrics? No. Okay. What if you're a guy named Mr. Alanis and you put on your Facebook page rap lyrics that involve basically raping and killing your ex-girlfriend? It's not directed at her, it's on your Facebook page, but it involves very graphic and not so different than Eminem, right? The Supreme Court said you cannot prosecute him for that. Complicated and simplifying a little bit, right? But the mere fact that you put rap lyrics, does that save the threat? Yeah.
It's pretty much the same thing.
Yeah, because part of it there was no indication that was done in a threatening manner, although the evidence there probably conflicted. So in many respects, the First Amendment protects speech that we don't like. But that's the exact type of speech we want to be protected. If it's speech that makes everyone happy, it's not going to need any protection. It's speech that people make feel comfortable. That's what's at issue. let's move to the first case, New York Times versus Sullivan, which is a really interesting fact pattern. Did you do this case in torts? Ah, good. Okay, so where the heck was that? Did he leave? He was next. I'll call him first next time. Okay, Jennifer, what were the facts in please in New York Times v. Sullivan?
Okay, so, police officer in Alabama.
Police commissioner, yeah.
Police commissioner in
Yes, ma'am.
Alabama. He,
By the way, who is New York Times? What is the New York Times? Corporation. Who's asserting a First Amendment right? Corporation. I only dwell on that point because people get so angry about it that there have been cases for decades where corporations are free speech rights. Right? Go on. So, what are the facts here?
okay, so, the New York Times, along with, some other, civil rights activists, published an article in the New York Times, in the New York Times, describing situations, describing events that happened, and they misprinted a couple of things.
Well, they didn't just misprint it. Specifically, what, and this is actually advertising. This is very famous. The Heed the Rising Voices. So before the internet, the way people fundraise is they would put an advertisement newspaper at the bottom. You see this little thing you cut out. Remember this, right? And you'd mail it in with a check. It was a fundraising pitch, right? We don't have the internet. It's the way you would actually solicit fundraising by taking a full-page ad. In the New York Times, they look, here's this problem, right? We have all these things going on. We need your help. And here are all these people signing it. And if you agree with us, here, cut this little, square out and mail in money to help our cause, okay? Very good. So, Brian, what was the problem with the advertisement as it was drawn up? No. The actual text of the advertisement, the copy of it. What was the problem?
Libel?
Was it accurate?
No.
Okay. What was not accurate about the copy of the text of the advertisement? Specifically, do you have it? Did you read it again?
Can I read it again?
Did you read the case?
Yeah. I don't know.
Kevin, what was inaccurate about the copy of the advertisement?
They said he had been arrested like 7 times. They said that he was accused of reading the campus with police.
Okay, good. So there were 2 paragraphs in the advertisement that were false. They were not accurate. So they made a statement that someone was arrested 7 times. He was actually arrested 4 times. They claimed that they ringed the campus. They didn't actually ring the campus. They claimed that they padlocked the students to starve them. That didn't happen. They made a number of false statements about the police. So first the threshold question, Caleb, is Mr. Sullivan in anywhere in this commercial? Is Sullivan's name appear anywhere in the commercial?
I don't think so, no.
So why was he so offended by it?
Because it seemed obvious that he was the one they were talking about.
Okay, good. They were talking about the police of Birmingham, Alabama, the commissioner. So it was a safe assumption that they were talking about him. Okay? So Clint, the next question is, under tort law, if you publish a false statement that injures a person's reputation, what is your cause of action?
Libel?
Yeah, libel, right? If you publish a false statement that injures someone's reputation, it's libel. Were these statements false, Clint?
Parts of it, yes.
At least some of it was false, right? Did they injure his reputation?
That's debatable.
Come on, look at this guy. Look at him with his family, right? Here he is with a police horse as they're staring at the civil rights marchers, right? Did this impugn his integrity, right? I'm sure someone's saying he's slander proof, right? But yeah, it did. I mean, under traditional tort law, if you make false statements about someone and it injures their reputation, then it's an action for slander. For libel. And usually this would be libel per se, because you can't, there'd be basically automatic damages. So traditionally, a libel action was not something that would even get to the federal courts. It would be a purely matter of state tort law. But this was appealed on up from the Alabama court system. Okay? So the first question, Iris. Why does the First Amendment even apply here? This is a lawsuit where Sullivan is suing the newspaper. Why does the First Amendment even apply here? This is not a law saying that you can't, censorship. Where's the state action here? It doesn't matter. Why would that matter? If I sue you for libel, are either of us state employees? So then why is the First Amendment even applicable here? What's the state action? Remember a case from property called Shelley v. Kramer? Did you do that one, Shelley v. Kramer? So I'm saying yes, I'm saying no, which means maybe. Who remembers Shelley v. Kramer?
The one at the restaurant?
Racial restrictive covenants. You did? Never mind. Okay. So there was a case from property, which apparently you didn't cover, called Shelley versus Kramer. And the facts of the case were like this. A home had what's called a racially restrictive covenant in it, which means that you could not sell the home to someone who wasn't white. Someone went to sue to enforce the covenant in court. And the Supreme Court held that enforcing that covenant would be unconstitutional to violate the 14th Amendment. Wait a minute. This is a suit between private parties. Where is the state action? Anybody want to guess what the state action is? Don't want to guess. Why would the state have what's the state interest in enforcing this action? How does it work? No, there's no statute. Purely private covenant. What? Yeah. Yeah, but who's discriminating? Private parties. Private parties can discriminate under the Constitution. Anyone? Come on. Yeah.
Well, don't they have an interest in keeping, the state officials and reputation?
Doesn't matter if it's state official. Libel works the same with its private parties. Anyone?
Was it thought that a libel would have a chilling effect on speech?
No. Much easier.
Interest of a citizen of their state against
No.
somebody else?
No. I'll give you a hint. Keller. Who's enforcing the judgment in this case? If a libel is found, who's going to enforce the judgment? The court is your state action. How do you enforce a covenant? You go to court. What if you have a discriminatory covenant? The judges are there to enforce it. So this is the same idea. Even though it's a suit between private parties for tort, which is, no state action, the fact that a court has to enforce the tort, that rhymes, the court enforces the tort, renders it state action. Therefore, a libel action is within the scope of the First Amendment. That wasn't entirely clear, but Justice Brennan, in his usual manner, slides it in without really making a big fuss about it. That because the court is responsible for enforcing the libel action, this is now state action, and because it's state action, a court cannot enforce an unconstitutional judgment. A court cannot enforce a judgment that violates the freedom of speech. You don't get that much. You understand that? Okay, very good. So usually, right, if there's a libel action, the defense is truth, right? You try to assert, you know what? These are true statements, therefore it can't be libel. But Bridget, these statements, are they true?
No.
Oh, I'm sorry, Terry.
Isn't this an advertisement though that isn't protected by?
Oh, get there in 5 minutes.
Okay.
That's my next point.
Never mind.
So usually the defense to slander or libel is truth, right? Here, though, Bridget, why does Justice Brennan think that truth isn't enough, or the defense of truth isn't sufficient?
Is it because they flipped the burden of proof? And that
Oh,
was
good.
on
Who has the burden of proof under this opinion?
Sullivan,
Why? Who usually has the burden of proof in a libel action?
the defendant.
The person who made the libelous statement, right? Usually the person with the libelous statement must prove that it was true. But who has the burden here?
The plaintiff,
And what does he have to prove?
actual malice.
Okay. This is Justice Brennan. I think I've said this before. In the very last sentence of the section, everyone knows that the very last sentence of section 2, right above where section 3 is in the opinion. I don't know someone yelled a page number. Was it 856, right? Whatever it is, 58? Okay. In the very last sentence, Brennan does this all the time, where he just basically futzes around and says whatever he wants. And the very last sentence, he gives you the test, right? And Bridget said it correct. The constitutional guarantee requires, we think, we're not sure, but we think, right? Maybe, a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct, unless he proves, not the defendant, but the public official proves, that a statement was made with, quote, actual malice. That is, with knowledge that it was false, or with reckless disregard of whether it was false or not. What's that? Cameron, what does that mean? What the heck does that mean that Brennan just dropped a bomb in the last sentence of the opinion, or the section? The sentence we just read. You can read it again. What does that mean? That's basically the holding of the case in one sentence. Brennan was very good at that. What does that mean, Cameron? Nikolai?
Well, it means that he has made kind of a test.
Yeah. So what's the test?
The test the provision if it's constitutional.
When is a libel action unconstitutional? At what point?
When it doesn't take into account if there's actual malice.
Okay, good. Right. So usually, for hundreds of years, the test for libel was it false? Did it injure your reputation? Boom, libel, right? Black letter. But Justice Brennan, from sources unknown, divined a new principle, a federal rule, he says federal, that a libel action cannot be heard if there's a public official. Who's a public official? Footnote, we don't have to decide that, but this guy definitely is, right? It's Brennan. Is this a public official? If so, the plaintiff, not the defendant, the plaintiff has the burden to show that the statement was made with actual malice. In other words, Sullivan has to prove that the New York Times knew the statement was false, or they published it recklessly. They have to prove that the New York Times knew it was false, or they did so recklessly. So Toshiba, what happens, and these are the facts of the case, if the newspaper was, under a deadline, they fact checked it, it looked good enough to them. There was no Google, then they couldn't Google the stuff, right? And they did an okay job. Maybe they made a mistake, but they thought they were doing it right. Is there any actual malice to those actions?
No, I think they said they trusted the people that were giving.
Good. So effectively, this makes it that you have to prove that it wasn't just an honest mistake, that they deliberately said it wrong. They deliberately lied to hurt you. What does actual malice mean? They act maliciously. They were trying to maliciously hurt you. This wasn't, an even-Steven honest mistake. Everyone get that? So under the First Amendment, they have to prove they actually deliberately tried to harm them. Okay, so now the harder question, Jennifer, why did Justice Brennan think that this additional layer of protection was necessary? Why did he think that it was necessary to make it harder for public officials to sue individual parties? What does he look to? What's his thinking on this? Well, Jennifer, let me ask like this. In the facts of this case, who is Sullivan? Sorry, louder?
Oh.
Who is Sullivan? He was a police commissioner, right? Who is he suing? No. Who is? And why was he suing the New York Times?
Because the wording.
What did the New York Times do?
They were talking about
Whose story were the New York Times telling? Who paid for this ad? So, who paid for this ad to get this ad out? Civil rights groups. And why were they trying to put this advertisement out? What were they trying to get? What was the goal of this? They're trying to get money, right? Just think about this, right? You're in Alabama, and was it 1958? A bunch of civil rights leaders are trying to put a commercial in the newspaper to raise money for civil rights awareness. And what happens? The commissioner of police sues them for libel. Everyone see what's going on here, right? Why do you think the guy, the commissioner of police, really cared about the libel action? Why did he do this? He wanted to shut them down. He wanted chill speech. Does everyone know what I mean when I say chill speech? He wanted to make it that speaking will be so expensive that you think twice. If every single time the New York Times put an advertisement to raise funds for some civil rights cause, and they had to employ fact checkers, right, and make sure that they had it right. Why? They don't want to get sued for $500,000, whatever it was. That was a lot of money back then, right? The entire ad was only $5,000. Do you think any newspaper would run an advertisement that maybe questionably criticizes someone in the government if they can be sued for this amount? This was an effort to chill the civil rights movement and to shut them up. I think that, more than anything else, explains the outcome of the case. The reason the case is dargle-bargle. It doesn't make any sense. Where this actual malice standard came from, who the heck knows, right? But the result is something that people may like, that you should not be able to sue a public official. I'm sorry, a public official should not sue the people who work for him, right? He is a civil servant who's meant to serve the people. Can you imagine when you criticize the government that you get fined, or if you go to jail? Amanda, can you imagine ever that in our country, people who criticize the government go to jail? Can you even conceive of that? When did it happen? In Brendan's opinion, when did it happen? That in our country, people who criticize the government were sent to jail. When did this happen? Sophia? The Alien and Sedition Act of 1798. Remarkably, not even 7 years after the ratification of the first round. 7 years, right? Not even 7 years after the ratification of the First Amendment, the Federalist Congress, under President John Adams, enacted the Alien Sedition Act. These laws made it a crime, punishable by fine and indeed jail time, to criticize the government, to speak sedition, to criticize the state. Okay? These laws were considered so pernicious, so evil, that James Madison and Thomas Jefferson wrote what were called the Virginia and Kentucky Resolutions, that effectively said that states did not have to follow laws that were unconstitutional. You think this started with slavery? It started here. The idea that states could ignore federal laws that were unconstitutional came from the pen of Jefferson and Madison. They said that these laws are such a blatant violation of free speech, we should not follow them. Indeed, when President Jefferson was elected, he pardoned every single person convicted under the statute. Congress actually passed a statute to pay back any fines that were offended under the Alien Sedition Act. Was the Alien Sedition Act unconstitutional? Well, it never made it to the Supreme Court. But Circuit Justice Marshall, good old John Marshall, right? He had a trial for a conviction under the Alien Sedition Act. He found no problem with this law. Again, not a John Marshall fan. For a lot of reasons. But Brennan basically says like this. Even though the court, I'll get you in a second, Michelle. Even though the court never did the Alien Sedition Act, everyone agrees was awful. So if you can't throw someone in jail for criticizing the government, how can you have them a civil judgment against them, right? If you can't lock someone in prison for criticizing the government, how on earth could you make them pay a civil judgment of $500,000? So Brennan, and this part's actually more defensible. So in fairness to Brennan, he says, listen, we can't have a system where you can sue the government. I'm sorry, the government can sue you and you pay up. That's censoring people the same way the Alien Sedition Act did. I think the correct answer is that libel laws are unconstitutional. I don't see how any libel is constitutional. Screw reputation, but I'm a minority there. Yeah, Michelle?
I know you'll tell me if I'm wrong. So,
Of course.
You're never wrong.
but why is it okay to print something, let's say everything in it was false?
Yeah.
I mean, what is it? Everything on advertising, because it turns out they even had names on there that really had not signed on. I remember that in the court case. So there's a whole lot more to the falsehood of it. And I appreciate the court could see through what Sullivan was doing. Okay, trying to silence the civil rights movement. That's great, but what happens when they can't, or they're saying it wrong, and someone truly has been injured, and someone has made up.
Right. So this is why the libel tort has been in tension with the First Amendment for 200 years. I don't think libel is constitutional. I really don't. You're punishing purely speech act. But the courts created this narrow exception where if I sue you, neither of us are public officials, it's fine. But if you're a public official and you sue me, you have to make sure I did it deliberately. If every single statement in the document was false, that may be proof that it was done with actual malice. Right? A couple errors here and there is maybe more forgivable. I mean, look, the errors here, they were pretty minor, right? They sang the wrong song, 4 arrests instead of 7.
Yeah, and I can understand that.
I mean,
being wrong.
but if everything in the thing was wrong, that'd be a stronger case for libel. Yeah, Sophia? Oh, yeah. Also, if the public official's unpopular, throw the bum out of office, right? You don't need, they're accountable to the people in different ways. Their reputation isn't quite as important. Yeah. I mean, I think this part of the Brennan opinion is actually more defensible. So Terry raised a point a minute ago. I'm sorry, not Terry, Darrell raised a point a minute ago. Isn't this commercial speech? This was a paid and bought for advertisement. It was not a letter to the editor. It was not an article. It's a paid and bought for advertisement. The court brushes this away very, very quickly and says, well, you know what? This is about matters of public concern and the civil rights movement expressing an opinion. They don't forfeit the protection just because they paid for it. Okay. So even if you're paying for speech, as a commercial is, it's still protected. This leads into something known as commercial speech. I'll say this in the lecture for next class, but the idea of commercial speech is very complicated, and I don't want to get to it too far today. So here the court holds, in order to have a public official sue someone for libel, the public official has a burden of proof to show the statements were made with actual malice, that is, with a deliberate, reckless regard of its truthiness, as John Stewart would say. Yeah.
So it would have been smarter for Sullivan to have just placed an ad in the New York Times counterpointing everything he thought was wrong.
Well, I mean, he could do that, right? The lesson of this case is a solution to offensive speech is more speech, which goes back to my shtick before, right? If you don't like speech, don't sue them. Don't shout them down. Give your own speech. This is what's often called the Barbra Streisand effect, if I may. So years ago, there were these paparazzis who would trying to photograph Barbra Streisand's house, and she made this big suit, right? And of course, once they make the suit, everyone goes and takes more pictures, right? Don't draw attention to things; usually makes it worse. Libel actions seldom actually make anyone happy. Just let it go away. If you draw attention to yourself, I mean, look, Sullivan's name forever is burned into case books. We have no idea who this guy is, but like he was probably a jerk, right? We talk about him over and over again. Don't just let it go. The internet, your reputation sucks anyway. I mean, if they want to watch the South Park, there's an episode a couple weeks ago where people tried to censor the internet for all offending comments about them, and it was this awful, awful process in my safe space. All right, any other questions on the New York Times case?
I guess I had one little question.
Yes, sir.
Brennan never really addresses exactly where the level is of a public official. So how far down do you go, or how?
So in a subsequent case, some years later, they tried to refine that. It was a case called Gertz versus Welch, a 1974 case. And they have, and there's another one. What the heck was it called? I'm drawing a blank. Yeah, Gertz, where they basically tried to say you want the test, if an individual achieves such pervasive fame or notoriety, he becomes a public figure. Pervasive fame and notoriety, if that helps. Or if a person, quote, voluntarily injects himself into a public controversy. That's also a public figure.
It's not even an official, just anybody, like celebrities and
I think there was a lawyer. I think
candidates
it
and all
had
that.
to do with a lawyer who was
Yeah.
representing them.
Yeah, it doesn't really matter. It's Brennan. I mean, I don't say it lightly, but this is what we call a train ticket. It was meant to solve one case and this one, right? But it applies elsewhere. So the last case I want to cover today begins the concept of categorical exemptions. So generally speaking, all speech is protected and it's afforded something approaching strict scrutiny. But there are certain categories of speech that are not protected. And one of them is called the fighting words category. Now, I want to preface this by saying this case is probably not good law anymore. Okay? There has not been, I mean, to my knowledge, any Supreme Court cases that have faithfully relied on this in years. So this is one of those categories of excluded speech that probably doesn't matter anymore. But I will teach it regardless because it's in your book. So the facts of this case, hold on, up to, Renee, what were the facts here?
Well, Mr. Chaplinsky, let's go to the Jehovah's Witness, sidewalk, City Hall, getting some stuff and handing out.
What was he handing out?
Religious
He was handing out pamphlets about his religion, Jehovah's Witness. Yes. Go on, please.
and then he was told by a traffic officer to stop.
Okay.
Because there was a law against saying offensive language outside the public.
Okay, good.
So he said that
And then he was arrested. What did he say that was so offensive? You can read it. Lexi, cover your ears. No, I'm kidding. It's okay.
Said you're goddamn racketeer, a damn fascist, and the whole government, a Rochester are fascists, or Indians are fascists.
Okay. So effectively, he was arrested for telling a police officer, "You're a goddamn fascist." Let me tell you what actually happened. The actual facts here are actually much more. There's newspaper coverage, which is quite different. So here's Chaplinsky beaten by a rape mob. So yeah. So the actual facts here are actually quite different. So Chaplinsky was preaching in a town square, and he was surrounded by people who mocked his religion. Okay. One man attempted Chaplinsky in full view of the town marshal, who warned Chaplinsky that he was in danger but did not arrest his assailant. So basically, someone threatened to beat up Chaplinsky, and the cop said, "Chaplinsky, get out of here." Who are you punishing? I don't know. Okay. After the marshal left, another man produced a flagpole and attempted to impale Chaplinsky. America, right? While Chaplinsky was pinned against a car by the pole, other members of the crowd struck him. A police officer arrived, and rather than dispersing the crowd, they arrested Chaplinsky. So this guy's getting the crap beat out of him, right? And he gets arrested. En route to the station, the officer and the crowd insulted Chaplinsky, so the cop is insulting him. Chaplinsky replied to the cop, "You're a damn fascist and racketeer." And then the cop arrested him for cursing him out. The facts are so distant from what's in the opinion. It's not even funny. It's like they're beating the daylights out of this guy. They're impaling him with a flagpole, like Captain America, right? And then he says, "You're a goddamn fascist," and they arrest him. Okay. So this is why I say this case doesn't really matter anymore, because the facts are absolutely insane. But let's pretend the facts are as they were. So Janine, why does the court hold that the conviction for saying you're a goddamn fascist is constitutional? What's the ruling here?
Fighting words.
I can't. Yeah. Fighting words. Fighting words. What are fighting words, Janine?
They're words that will provoke or kind of pump up something that you want to do or something else.
Yes. Okay. So in short, fighting words are words that will make a reasonable man, whatever that is, want to go to fisticuffs, want to go to fight someone, right? So if I call someone a goddamn fascist or a damn racketeer or whatever it is, I think I called someone a fascist tonight. We didn't have any fighting words. Fascist, that was not an undeliberate word. That was somewhat planned. That is a fighting word. So the court says that this conviction could be held. The reason why I'm telling you this case doesn't really matter anymore is because under any circumstance, if I call someone a goddamn fascist, I am speaking constitutionally protected. This case, what, 1940, whatever, 42. This case was long before the First Amendment started getting some weight. Although it's never been overturned, it's still good law. So I want to go now through my remaining few minutes, a number of cases that are mentioned in the notes. So a case called Cohen v. California. So Lexi, you can cover your ears now. A guy walks to a courthouse. He was a hippie. And the jacket says in the back, "Fuck the draft." Okay? And I say the word fuck deliberately because it elicits a reaction from people, apparently not Lexi, of why. It's okay. If you would imagine the 1970s, the height of the draft and the height of the war, right? To actually, seriously, I talked to Iris beforehand. I warned her. If you actually use this language, it's offensive. If you were someone in the service, and you see this hippie walking into a courthouse saying "fuck the draft," you're gonna get offended. You may want to deck the guy. Is there much of a difference between "fuck the draft" and "you're a goddamn racketeer"? I think they're in the same wavelength, right? But in Cohen v. California, the court invalidated the conviction for wearing the jacket. Okay, another case, which I think we'll talk about next class, Texas versus Johnson. Texas passed a law criminalizing flag burning, the American flag. And the court held that, yeah, that's offensive, right? If you see someone burning the American flag, you want to deck the guy. But even then, you can't criminalize it. There's a brief case in the reading for next week involving a recent case from Michigan, where you had these Christian preachers go to a Muslim civic festival and start holding up all these signs saying how Islam is evil, holding up a pig's head on a pipe. A pig is an unclean animal to Islam. And then what happened? Well, the people at the festival started throwing rocks and bottles at them. And what did the police do? Did they stop the rock throwers? No, they arrested the preachers. And I think the court correctly held in favor of the preachers there. So the mere fact that speech is offensive, and even speech that makes you want to punch someone, right? The word on campus is unsafe, right? That speech makes you feel unsafe, right? Microaggression, right? It's not that you're actually hurting me, but you make me feel physically, mentally unsafe. Rubbish. This is all free speech. Don't buy it. The book lists at the end a number of categories of speech that are categorically exempted. Again, these are somewhat wishy-washy. I don't think they really have much weight. So the first one, number one, fighting words, right? Chaplinsky. If in fact you engage in fighting words, that is not protected speech, but I'm telling you that's probably not good law anymore. Number two, true threats. This one is probably good law. You don't have the right to threaten someone. And that doesn't mean like, oh man, I really hate the guy. It's like, I'm going to kill you. I am going to punch you. I am going to dismember you, right? And that's not just actually just like mouthing off in a rap lyric. It's actually, you know what? I'm going to kill you now, right? There's a resonance to it. And the case there is cross burning. And the court actually held that merely burning a cross, which is an odious act of the Klan, by itself was not a threat. It could be, but wasn't. You'll read a case next week, a next class involving Confederate flag license plates. That does not mention this case very deliberately. I'll explain why next class. Defamation, so libel and slander, libel and slander suits are allowed, but the actual malice standard for public officials. And even the case United States versus Alvarez, 2012 case, decided the same day as Obamacare. Oh, Mildred's not here. I was saving that one. Alvarez was decided the same day as Obamacare. I remember I told you I was in the airplane and I didn't have anything. I managed to download Alvarez before it took off, so I actually read the entire case in the plane. Then when it landed, I got to Obamacare. But anyway, so Alvarez says you can't prosecute someone for lying and being a Medal of Honor winner. That's number three. Number four, commercial speech, speech of a commercial nature. It's given less protection, although that area is very murky. Number five, child pornography is the exception. Child pornography gets no free speech protection at all. Why? The idea is if we allow child pornography, there'll be more pedophiles who rape children, right? We need to stop molesting of children, and we do this to criminalize the source, criminalize the actual act of recording it. Also, obscenity, certain speech that's very offensive, that lacks any kind of literary value, that's not protected. Is anything obscene anymore in the age of, millennials? I don't think so. There was actually a case involving 2 girls, 1 cup. If you know what that is, don't Google it. That's not obscene, and if that's not obscene, nothing is. And famously, Justice Potter Stewart said, "I know it when I see it," but that test doesn't get very far. Another category is crime facilitating speech. So for example, speech that can be used to carry out a crime, although that doesn't even matter much. For example, the Anarchist Cookbook, a book that can be used to make bombs and pipes, that is constitutionally protected. As I argue in my brief, so are plans to make 3D printed guns are protected as well. And there are a few other topics that we'll cover next class. Okay. Any questions? I know I'm running through this real quick, but we don't have much time for free speech, unfortunately. Any questions? Yes, sir. It's never been overturned, but I can't imagine the court actually upholding an arrest. I mean, if you look at the statute of Chaplinsky, it says, if you say anything offensive, right? I led this class by saying offensive speech is protected. I'm right about that. So I don't think that sort of statute even work. Other questions? Have a wonderful day. I will see you on Wednesday, and have a safe drive home.